if we can get to Detective Janoris this morning and start her testimony, that would be ideal. If not, she can testify in the afternoon. And
she's the state, right?
Correct. She's also going to. I'm also going to be introducing a jail call through her as well, and publishing a jail call.
Is there an agreement from the parties on the contents of the statement?
So
that need to be skipped over and redacted?
So late last night, I finished going through the entire 11-hour statement. I finished around 2 o'clock in the morning. So I didn't want to call Mr. Tomas at 2 o'clock and wake him up. I have timestamps of what I believe are either irrelevant or inadmissible. Mr. Tomas and I spoke briefly this morning. The only actual issue I believe that exists, there is a point in time in which when Detective Janoris walks in at some point, she goes to Ms. Lang, I have a question for you. What happened on Monday? And I can't remember the exact words that are used, but Ms. Lang volunteers that she smashed the window of the truck that we discussed during the Williams rule. Ms. Lang's response to all that in context is that was immediately after the victim had pistol whipped her. I can mute that portion in time because obviously the court says that could not be used as a Williams rule. I do think it's relevant in this case, in that context, but if the court's order is that cannot come in, I'll mute that entire portion.
So Janoris comes back in, and that's an isolated mini conversation.
Yeah, it's I have no timestamp here. It is during the full 11-hour statement. It is at 8:29. 8 hours and 29 minutes, and it goes 8 hours, 29 minutes, and 17 seconds.
But it is isolated.
Correct, yes. That's the only actual portion about the truck that's ever involved, but I do think it goes directly to the state of mind of the defendant. It goes directly to the defense's argument that had been brought out multiple times now that the victim had pistol whipped her prior to, that she was in fear, et cetera, et cetera. I think it goes directly to her state of mind. If the court's ruling still is that I cannot bring that up, I would just ask to revisit it on rebuttal at that point in time, but I understand whatever the court's ruling is.
Let's just work backwards. Do you want that in or out, Mr. Tomas? Okay, so it'll be redacted.
Sure.
Muted, however way. The other parts regarding this person getting arrested, that person getting arrested, are both sides in agreement for those?
So I've muted, let me phrase it this way. I have my lit support currently working on muting all specific mentions of any actual acts of domestic violence or arrests that are brought up. I intend to elicit testimony from Detective Janoris that this was a volatile relationship, that there were acts of domestic violence that were occurred, but I don't want to get into the specifics because, as Ms. Lane mentions,
let me ask you this: how are you going to ask Janoris about their relationship?
Did the defendant tell you that this was a volatile relationship? She actually, the exact words that Ms. Lane uses in her statement was this was toxic as hell.
Okay.
Did she tell you that this was a toxic relationship? Did she tell you that it was volatile? Did she tell you that there were acts of domestic violence that were committed by Pedro Jimenez against Ms. Lane? She will answer yes.
But all of those words that came out of Ms. Lane's mouth are in the report, right?
To a certain extent, yes. Ms. Lane gives specific examples. She says she woke up in a bathtub. She doesn't give a time, a date, anything like that, but she says it happened a while ago, which is also corroborated by Ms. Lane's statement to other officers that, yeah, Pedro had a past, but that was very long ago. Ms. Link also talks about how, with the bathtub incident, she says, well, that was the last time I got arrested.
But why revisit it again with Janoris? What's the purpose?
Because as of right now, those things really haven't come into evidence, right? The actual acts of domestic violence that are spoken about are not really.
But what's the purpose of having Janoris highlight?
I'm not highlighting.
Half a dozen, so.
No, I'm not going to have her speak about any of them. And as we talked about yesterday, the only thing that I'm going to have her talk about is did Ms. Link tell you it's a toxic relationship, etc.? Did she tell you there were acts of domestic violence? I don't intend to have her say, yeah, she told me about the bathtub incident. She told me about this. She told me about that.
I'm not answering my question. What's the point of having Janoris repeat these? The jury's already going to hear it from the video. Why?
No, they're going to be muted because, again, the court's rulings during the motion in limine that those specific acts were not coming into evidence. The only actual act that was going to be discussed was the pistol whipping incident from 5 days ago. So what I'm asking Detective Janoris to testify to is, did Ms. Link tell you that there were acts of domestic violence? She will say yes, and then I will stop. Did she say that there were acts of domestic violence that Ms. Link also committed against Pedro Jimenez? She will say yes, and then I will move on. And the reason why is because it shows the totality of that actual relationship, and it's inextricably intertwined with my theory of the case that this was a toxic, volatile relationship with domestic violence going both ways.
So, Judge, what I would say to that is nobody's disputing that this was a toxic relationship. My concern is we have a statement where Ms. Link talks about why it's a toxic relationship, but we're going to mute that, but then we're going to let this person give a secondhand account of a statement that's going to be in, but it's going to be redacted. I don't see why those two scenarios should coexist.
Well, so I don't have to play the statement at all. I don't have, I can publish only even portions of it. The law is incredibly clear that I'm allowed to present evidence as I want to, that this is not applicable to the best evidence rule either. And again, the court has already ruled that those specific acts of violence, either way, are not coming into evidence.
So then why would I allow Janoris to say orally? They can't come in.
I'm not going to ask her about specific acts. I'm going to ask her, did Ms. Link tell you about Mr. Jimenez committing domestic violence? Did Ms. Link say she committed domestic violence? I'm leaving it in a very broad sense because Ms. Link talks about her actual arrest, which I don't think, based off the defense's arguments last week, and the court's inclination prior to, that can come in, right? We're talking about the second phase of the case at that point in time. Same thing with the victim's arrest. She says he was arrested for this, the bathtub. He wrote a letter to his mom. None of that is relevant to this case.
So you want to be able to corroborate that there was domestic violence on both sides.
Correct, which is my theory of the case.
So what we want to do is the half dozen or so specific incidents from the actual video, based on my ruling, should come in. But the state still wants to paint a picture that there were acts, not necessarily criminal acts, acts on both sides. And it sounds like a pretty general, they want to elicit pretty general evidence from the detective regarding that. I think based on the way that they want to elicit it, it won't be a feature of this detective's testimony.
No, it'll be seconds.
So what's...
Well, if it's limited to the very general questions that he just...
Yeah, I misunderstood. I thought you wanted Janoris to say, was there rats in this?
Absolutely not, no.
Okay, that was my bad.
Okay, so if it's limited to those very general questions, then
Right, and so it goes into their theory of there were ups and downs.
That's
you
fine.
used the word volatile, so I'll allow that.
Judge, I want to give you a heads up. I just sent you an email. I copied the state. So there is an order dealing with the custody of the kids. I did locate it. It's part of the dependency case. The clerk will not give me a copy unless you sign an order. So I'm asking, I sent you a proposed order. I don't know if you want to tweak it a little bit, but I tried to cover all the bases there. They don't have the file right now because it just so happens that just yesterday they finally quashed that pickup order, which had been outstanding for a long time. So just so the court knows, now that that pickup order is quashed, maybe Ms. Link's mother will change her mind and provide Pedro Jr. I'm going to be at the state attorney's office on Monday morning to conduct depositions anyways. So if she brings Pedro Jr., then we can resolve that on Monday morning. If she doesn't, I have no control over what she decides to do, but just wanted to make the court aware of it.
We'll still need to litigate a few things regarding that child, and then I would also, so I don't know the statute off the top of my head, but there is a statute that says any party, including the court, can move for hearing on whether or not it'll be traumatic to a child witness to testify in front of the defendant. If we get to that point, I'm going to be moving for that child to be given his testimony, not in the courtroom as well, but we can cross that bridge when we get there.
So I'll go ahead and have the set threaten me a copy of this. And it looks like it's fine based on my review. I'll sign off on it. But this is for your case sheet, right? This is for your presentation of your case, so you may not. Hopefully, they get it to you today.
They're not going to get it to me today, Judge. They said that if I show up, they're closed on Monday. I show up Tuesday morning at 9 with a certified copy, then they'll give it to me. I'd ask, because they don't have the file because it was in court yesterday, because they just signed that order.
Do you know which judge?
Probably not the same judge anymore, but.
How do I say this now?
I'm sorry. I just see how there's something. Oh, sure, thanks.
I'm not sure which judge it is, Your Honor.
Maybe some phone calls. But you want to present this when you start your case on Tuesday?
Yeah, it's a self-authenticated certified document. Looks like Michelle Alvarez-Barakat signed the order, the old order. I don't know if there's a new judge assigned to it now. It just says cancellation.
Still over there, so it's probably.
Okay.
We'll make some phone calls.
And Judge, I'll send you, if you don't mind, once there's a certified order, if there's a way that you can email it to this supervisor clerk, and I'll send you the email. Just, I don't know, so.
Once my JA gets it, I'll have her send it over to the clerk. She can copy both sides, and I think I can ask for a certified copy, which probably I'll probably get it before you get it on Tuesday.
I would think you would.
Let's hope they give you that. I'm sure they will. I'm sure they're probably giving that professional first.
Thank you, Judge.
There's one other issue that I spoke to Mr. Tomas about that I think is actually very.
Going back to the statement.
Sure.
We'll just talk about it over lunch.
Yeah, absolutely. I have, like I said, I have my own timestamps. I'm asking Mr. Appellate, the reason why I'm doing this is we don't have the actual statement yet. Like I said, I finished it late last night. I have timestamps, but when I went to my litigation support team this morning, their timestamps are used on a different program that is significantly more accurate than the program that I am given. They're off by about a minute or so. So while we're in the trial, Mr. Appellate is confirming the actual timestamps, but I have what I have, which I think.
What is he literally recording?
Basically.
Over the video?
Basically.
Your Honor, so there's essentially internal timestamps that are already embedded into the actual interview, so I'm just cross-referencing those.
And then I'll be able to provide a copy of that to everybody, but I can speak to Mr. Tomas about what I'm actually planning on redacting and removing from that video itself.
I wanted to, just going to tell them what to take the jury on that side. Can I revisit a little bit what we discussed yesterday regarding the
First Miranda?
Yes, but also the I'd like to file my email with the court as according to one. My concerns regarding the spontaneous statements. Okay, nothing in this email is anything different than what we generally discussed before. It sort of narrows down my concern about the way that the spontaneous statement came out, and my belief that the instruction I gave to the jury about how the jury should view the spontaneous statement, I think I'm correct. So I just wanted the appellate court to see what I was thinking and the case law that I provided to you all yesterday, so that would be Court Exhibit 1. Well, in the context that it was said, it was pretty jarring. I understand it may have fallen into the spontaneous statements category. We haven't heard all the evidence yet, and the jury is supposed to keep it in mind. If Ms. Moreno testifies and more evidence comes out about Ms. Link and her self-defense claims, I think that statement is less impactful. Does that make sense, Mr. Tomas?
Yes, sir.
We still have to look at we're only halfway through the trial, there's still half more evidence, half as much evidence that needs to be admitted, and there's something stopping me from saying something along the lines of the family knew it was quote unquote a bad relationship, and it's not unreasonable to believe that something bad was going to happen to either side, something along those lines, right? Okay. Not yet.
Yes.
All right. Did you and Ms. Link talk about the Miranda waiver?
What is it doing?
Yeah, what is the one?
Yes, she wants the whole thing in, including
I went back and I looked over the Miranda waiver in the second one. While the police say something along the lines of, so you want to talk to us, we have to go over your rights again. They use the word again a couple times.
Which, sorry not to cut the cord off, that's muted.
Oh, well, I was going to say, that doesn't indicate that she has invoked her right to remain silent. Just because they're going over the Miranda rights a second time or again, it's not a comment on the silence. So yes, the state is going to mute that. I don't think they need to mute that because this doesn't indicate that. My concern is a comment on the silence. So,
yeah, I would just ask they play it, but no commentary, no unsolicited comments from the witness like we had yesterday with that detective.
My point is, it's not necessary for us to talk about the first Miranda.
Yes.
Because the second Miranda doesn't indicate a comment on her silence or the invocation of any rights, number one. And number two, since it's in the benefit of Ms. Link to have this statement come in, I would think that we would want to streamline it.
Yes.
Do you understand what I'm saying? Yes. So if you, as you as a lawyer, believe strategy-wise, it's better for you to have the statement come in, it looks like it's coming in with certain protections. For example, the jury's not going to know that you were arrested. Does that make sense? Okay. So what would be the logic in bringing in the first statement where you invoked it?
Because they spoke to me outside of the door either way. They were speaking to me the entire time, even though they weren't supposed to. They basically coerced me into signing that second sheet when they took me to the bathroom with an entirely different investigator from the DV department.
But at this stage, you're agreeing that what's in the full interview is better for you.
Correct. Yes.
For this trial. So why can't we just move on and not from your point of view, understand that you're getting an overall benefit, even though there's parts of it that you don't agree with, the way that they got you to speak, for example.
I can understand that.
You also understand that there wasn't a motion to suppress filed. So the court didn't have the cops come in and prove to me that your Miranda statement was a knowing voluntary waiver. We didn't have that argument. That's a constitutional motion that could have been filed, just like the standard ground, but that wasn't in front of the court either, right? So that, to me, that's also like a strategic point of view, strategic move by the defense, right?
Yes.
Okay, so do you want to so it sounds like you don't want to talk about the first Miranda waiver.
Yes.
Okay, because if you do, you and I have to have an in-depth conversation about what it means for this jury to understand that you invoked your rights, and essentially it's a comment on your silence, which has all sorts of huge constitutional ramifications that need to be weighed in this courtroom for appellate purposes. Does that make sense?
Yes.
So why don't you just talk to her real quick about
Yeah.
us not going into the first Miranda?
Judge, I'm just going to step outside.
Yeah, I'll step outside too. You authorize Jason to do the little white seats?
I'll step outside.
Yes, sir.
And how are we proceeding on the first Miranda?
So,
ready for the jury?
No.
so we'll leave the first one out, and like you said, they're going to say, you're going to read your rights again. That's fine.
I'm muting the part where they say we're going to read your rights again. It's just going to go into Detective Jean Norris. I can show everybody later when I have the actual redaction because I don't remember it.
Do you think it's
I just don't want any mention of again or anything like that.
I would ask that again, State. That's the one thing.
again, it's fine, because it's not a comment on her silence.
Right, but it implies that she was already read her rights, and that's my fear. If Ms. Link is willing to waive that appellate right right to at least that portion of it. I'm okay with leaving it in. I'm just very concerned about even going near the idea that Ms. Link had invoked at any point in time. That's my fear, and as we have said a number of different times, I don't want this case coming back, which there is just case law after case law after case law that says any mention about any kind of first indication of Miranda rights is reversible error, and I don't want to even come close to it.
I know it's nuanced, but the second reading doesn't, it indicates a second reading. It doesn't indicate a indication.
But Your Honor, that when you see a first reading,
Right.
that will essentially be cut out.
And
Hold on, I understand where you're going regarding inference, but if you raise that argument, it is waivers, okay? And there's no evidence
Judge, respectfully, I'm not comfortable playing that if Ms. Link is not going to waive her appellate rights to that specific issue. I don't care about the first part coming in or her waiving there, but if there is a mention of we're going to read you your rights again, I'm not comfortable publishing that to the jury in any manner whatsoever. And the way I'm instructing Detective Janoris to limit that is, did Ms. Link approach you while you were fingerprinting her and explaining why she was being fingerprinted? Yes. What did Ms. Link say? Did you approach her? Did she approach you? She said, I didn't mean to kill him. Detective Janoris will say I said to Ms. Link, in order for us to talk to you, we have to go over your rights, and then I will discuss Miranda and discuss her waiving of Miranda and publish that portion of it. But I am not comfortable having any mention of again or anything like that, especially since we had a detective testify yesterday about Ms. Link not having to cooperate with law enforcement and objections sustained that were made by defense counsel about any kind of inference about her refusal to cooperate with law enforcement. I'm not comfortable, and I'm just not going to play it.
Understood. All right. They'll play with the waiver. And I still have to speak to Ms. Link about that. Are you agreeing?
So as far as to there being mention of the word again, yes, I will waive any appellate issues as it relates to that very specific part being questioned.
And are you in agreement with me that while it says again, and you have to go over your rights again, it's going to be the same form? The state is concerned that there may be an inference that there's a comment on her silence.
Right, so I'm waiving that specific appellate issue, yes.
Ms. Link, do you understand?
Yes.
So even though Mr. Tomas believes legally he can waive this, it really is up to you to decide if you're going to allow the state to play the full second interview, the portion we're talking about now, about police going over your rights again. So you understand that no one's going to tell the jury that you invoked the first time. No one's going to tell the jury that you invoked your right to remain silent. No one is going to comment on your silence, but you're essentially agreeing that that is not going to be an issue for appellate purposes. Do you understand?
Yes.
You've had enough time to speak to Mr. Tomas about that?
Yes.
Okay, do you need any more time to speak to him?
No.
Okay. Do you have any questions for me about what we just went over?
No good.
All right. Okay, so I think you have a waiver.
Yeah, so I'll talk to Liz Support about that later this afternoon when we actually publish that video and having that portion. There's a few other issues that I think are imperative to address. First and foremost, I walked outside, I made eye contact with one of the jurors, I recognized her, I said hello, I didn't realize who it was until I said that, and then there were a handful of witnesses around where the jury is, they're right outside the courtroom. I asked them all to just move away, so that way there'd be no...
That's fine, well, I asked them virtually, but...
Yeah, they're right there. I just wanted to make everybody aware of that. The second issue is I want to make sure that we are not proceeding forward on any kind of suppression issue, because Ms. Link specifically said earlier that she was coerced into waiving Miranda, so she's going to be...
I understand based on my conversation with her, she understands that no motion to suppress.
Right, I just want to make sure that that is also on the record. And then the third thing...
That's right.
Yes. Understood.
And then the third thing is, I spoke to Mr. Tomas about this. I spoke to Sergeant Crementini on my way into the office this morning. What he informed me was basically this. The phone extraction that is currently in evidence is the entirety of the phone extraction. However, that was done sometime about 2022. Sergeant Cremencini, who was working with a team at the time, now has access to better technology. And very recently, within the last week or so, he decided to plug that phone in again and do the extraction again on his computer. Additional data was able to be read at that point in time. He called me this morning and informed me of that. I sent those text messages over to defense counsel this morning. The way he explained it to me was no.
It sounds like I'm gonna have to have emergency.
Right.
Or late turning over the stuff.
Well, so yes and no, and I was going to suggest to the court that we do that, and that's why I'm kind of explaining it in the way I am. The way he explained it to me was this. Technology is ever changing. It's getting better, and as the technology gets better, the actual extraction itself is able to be read more fully by better technology. We now have better technology that is able to read that data and different data. The way he described it was basically like the DNA swab. DNA swabs get better over time. It's still the same blood, it's still the same DNA, however, you're able to read more. I sent over what he sent me today to defense counsel, which is a handful of text messages.
Please have a word to the jury all the way on the side, please. One man will communicate with me. You're too close to us, please.
Those text messages are between Ms. Link and somebody by the name or saved in her phone as, I believe, Smoke. Those text messages include references to shooting people, shooting Smoke's girlfriend, etc. As I said, and as the court indicated about the Richardson, I was going to successfully do one. I don't think it actually.
Why is Smoke's text messages relevant to you?
It's not. So that's what I was going to say. It's not a discovery violation because all that data still existed and was turned over. It's just a newer program that is able to read that data more. It's inadvertent because, again, we couldn't read it when this was actually turned over. It's prejudicial because it could affect Ms. Link's cross-examination or her testimony because she says in her statement, for example, that she didn't know anything about firearms, etc., but she's saying this to shoot other people. My remedy to it, I will not use it whatsoever, and it will be excluded entirely, and I'm going to direct Detective Cremencini to discuss on his direct examination the betterment of technology over time, and if he has done anything recently, specifically about the videos on Ms. Link's phone.
So it's only relevant, the betterment of technology is only relevant about the videos on the phone?
Correct.
Have those been played?
One of them.
All right, is there something else that's going to be played?
Yes.
And do you have access to that as soon as? You know what it is?
I'm not sure if there's any new information that I didn't already have.
So there's a few of them. There's the defendant and there is the defendant and the victim exiting the vehicle together, which I'm going to talk to him about the actual timestamp on Ms. Link's phone on that, which is somewhere in 10:30 time.
10:31, that's the day of shooting?
The night before. So the shooting happens at like 3 a.m. They get outside of the vehicle at 10, which is corroborated by Ms. Link's own statement. There is a video that I plan on publishing later with the children also, them acting as a family. And then the actual shooting itself, I was planning on talking to him about the timestamps.
And these are all 1 or 2 days before the shooting?
This is the shooting, the night of the shooting. These have already been turned over, and what I'm going to ask Sergeant Cremencini is, were you able to verify the 2022 extraction to whatever you did recently? Are the videos changed in any way? And he will answer no. He will actually say exactly, I believe he said it was 861 videos that were on Ms. Link's phone are the exact same from a few weeks ago to the day that it was extracted. There's no change whatsoever when it comes to the videos.
So, I guess just so the sufficiency of the investigation, they explain it that, which is why the testimony will come about recency and extraction of videos on the phone, even though they've had it for 3 years.
So it sounds like, at least with the videos, I have all the videos already. The
Yes.
only difference is that they were able to get timestamps from within the data.
No, so if you look at my computer, I'll show you. So if you look at, I know the court can't see it, but just for the purposes of the record, if you look on the actual Cellbrite report, which is what is furnished to me, the shooting occurs and there's a timestamp of when it was created at 6/25/2022, and there is a 6-minute and 57-second video. Part of that was published yesterday. It's created at 3:06 a.m. When this link is seen, it's about 6 minutes into the video. I'm going to have Sergeant Cremancini say, okay, if this is started at 3:06, that means that this occurred around 3:11, 3:12. Then I'm going to show him the call log of the defendant with the 911, showing that 911 was called around 3:21 a.m. All of this has already been in defense counsel's possession. Nothing with regards to the video has changed whatsoever. The only difference is that the technology changed so that we could better read information, and these text messages that were now being able to be read were now furnished to defense counsel. I do not intend to use them whatsoever. I wanted to make sure that that was on the record, that I am giving the remedy of that exclusion of that evidence, regardless of
and the few that you want to play, before said that she came looking for him at, what's his name, Brian,
Kevin Bonilla.
Kevin Bonilla's house. It goes hand in hand, that they were getting along.
Correct.
Until the time of the shooting.
Yes.
So it sounds like it's relevant.
So I don't have a problem with the better being able to pinpoint the time that the videos happened based on this new data. That's fine.
No. The extraction that I have, this is from 2022. Nothing has changed. What I'm talking about, the data being better and the extraction being better, solely goes to the text messages. I'm just going to ask Sergeant Cremancini, did you confirm when you got better technology, were you able to confirm that the videos that were extracted are exactly the same? There's no additional videos or anything like that.
So, Judge, my only concern would be bringing in text messages or anything else that I hadn't seen up until now, but it sounds like they're not doing that.
That's correct. That's
so
correct.
Then there's no problem.
Right.
And you have to be careful with the word confirm. That's a conclusion, right? Why don't you ask him?
Well, he can because number one, he's an expert. Number two, he will and can testify about hash marks and how you can confirm that the same data that is on the phone then is the same data that's on now. He will say they're the exact same hash marks.
So what? So you will start out by asking him, what's the date, whatever hash mark on this item versus this item, and then he can say factually that they're the same.
Yes.
And then you can ask him, do you confirm that they're the same?
Yes.
Do you understand why?
I do.
I'm concerned.
I do.
You just saying this and this, or are you saying, did you confirm?
No, I'm going to lay significant predicates before I even get into that.
Right.
And we can also go sidebar to make sure, or voir dire him outside the presence of the jury to make sure that everything that we do is in the correct way, so that way there are no issues later on.
I think we've taken care of what we're supposed to take care of before these next witnesses testify.
Yes, sir.
Who's going to be the first one?
We're recalling Detective Zapata. Sorry.
All right, so can I start?
Yes, sir.
Yes.
If you need to do something,
No, just gonna have to catch that out here. I'll send you a mess.
you want to share
I'll be watching.
I'm not sure which woods.
control of the wrong. Yeah, I'm moving that. Yeah.
All right, jurors coming in. Jurors coming in.
All right, the jurors